Okay. I've been getting pissed and getting pissed and getting pissed. I'm recording, by the way. I've been charged with tag attached, not assigned, and driving with no valid license. There's also an incidental civil charge in there too, but I'm not going to mention that because that's not applicable to this particular situation. Now, here's the thing. I'm going to fight this. The premise for my fighting this has absolutely nothing to do with that whole right to travel thing, which I get it. Personally, that's my view as well. But I have a different argument for which there is no precedent against this particular argument. I was on justanswer.com. I got lots and lots of responses about the right to travel defense, and they gave legitimate case law cites against that defense. So there is a precedent against that particular defense. Supreme Court precedent. Now, the defense I put forward is the question of the right of property and the right of lawful versus legal. Now, the issue with lawful versus legal is that lawful is pertaining to common law, i.e. the Constitution and the laws made in pursuance of it. It's in the freaking, I can't remember what it is. I think it's the Supremacy Clause, that this Constitution and the laws made in pursuance thereof, pursuance means in keeping with, shall be the supreme law of the land, and all judges shall be bound thereto. There's another section that says laws and statutes made to the contrary notwithstanding. Well, that notwithstanding is a legal term. It's notwithstanding, all one word, no spaces. It means in spite of. In spite of legislation made to the contrary, the Constitution and all laws that follow it are the supreme law of the land, and all judges shall be bound thereto. In other words, no unconstitutional statute can supersede the Constitution. So there's the basis of that. Now, there brings me to this argument. If an act is inherently, in and of itself, unlawful, no authority, governmental or otherwise, can grant you permission or license to do that thing. Okay? So, therefore, if they do grant a license, it is a lawful exercise, and they can give you a license to do it. Now, if you can do, and the license gives you the capability of doing it legally, as in under the letter of the law. If you can do a thing legally with a license, you can do it lawfully without a license. I'll give you an example. Marriage. Marriage is lawful. It doesn't violate common law. But states and statutes require a license for it to be legal. You can be married, you can be in a union without a license. You can be together without a license, but you cannot be recognized as legally married without a license. See what I mean? Now, that example is proof. You cannot take one situation and exclude it from the general rule. A license grants you permission to do something that you could not do otherwise. Okay? Lawful speaks to the freedom to do something. Legal places restrictions on that thing. Now, if a law, legal, is lawful, it has to do with the safety of the public, the safety and well-being of the public. Now, lawful legislation is something like the statute against reckless driving. Driving recklessly presents a clear and present danger to the public. The likelihood of causing injury or property damage while driving recklessly is such that it presents an articulable chance of injury. It presents an articulable actual risk to society. Now, there's that. The law that requires a license to legally drive a vehicle does not come from a basis of a public welfare issue. Yes, a license requires that you be tested and proven competent. However, it does not preclude those who have not been tested from being competent. The simple fact that you are issued a license does not mean that you are any more competent to operate a motor vehicle than anyone else. It simply states, yes, this person has been tested and proven competent by a recognized authority to operate a motor vehicle. All it does is gives you proof of your skill. That's it. It means that you can prove your skill. There is no precedent that states being unlicensed and operating a motor vehicle in general, in keeping with safety regulations of the road or common law, presents a clear and present danger of articulable quality to make it a safety concern. There is no proof that an unlicensed driver will be less safe than a licensed driver. There is a precedent that they may be, they have the opportunity to be, but there's no proof that they will, in fact, guaranteed, be less safe than a licensed driver, which places a restriction on the privilege or on the right of using personal property. And that's the thing. You buy a motor vehicle for its primary intended purpose, which is to use it, to travel with. Requiring a license places an undue restriction on that use, as does registration. Registration requires a use tax on the vehicle. Now, how does that use tax benefit the public in a way quantifiable? It doesn't. Well, the use tax goes to maintain the roads, and without it the roads would be crap. Wrong. There are so many different taxes that go towards the roads that the loss of revenue from the use tax charged under the registration is a drop in the bucket. Okay, so there's that. And here's the thing. If a law does not specifically prohibit something, how can it be said to be illegal? Okay, there is no law that prohibits an unlicensed person from purchasing through private transaction of a person-to-person means, the sale of private property from one person to another. There is no restriction on that. There's no law that states that if you don't have a license to operate a motor vehicle, no one can sell you one. Those operating in commerce cannot sell you a vehicle without proof of licensure, but a private citizen has no such restriction. It's personal property. Once it becomes yours, you can do with it as you wish, as long as what you wish to do does not pose a danger to persons or property of the public. Okay? So if there is no restriction on purchase of property, how can they lawfully restrict the use of property by anyone who is legitimately allowed to acquire that property if it is not articulably in the interest of public safety? They can't. That is my argument. It has never been argued before in any superior appellate court or the Supreme Court. My problem now is that, yes, I think this is a real and compelling argument, but right now I'm in traffic court. I am an indigent individual. I have no income. I've been told that I'm not entitled, I don't have the right under the Due Process Clause to representation paid for by the state past the original trial. Now, I want opinions from anybody watching this. Does that violate the Due Process Clause of equality under the law? If people who can pay for a lawyer are entitled to legal representation at every single step of the judicial process, can those without income be denied that representation at every single step of the judicial process? Period. If we have a right to appeal, which we do, it's written, I can't remember what freaking publication it is, but there's a governmental regulation that states every person convicted in a criminal offense has the right, common law, constitutionally protected right, to appeal the judgment to a higher court. Period. And continue to appeal until the final appeal court, the Supreme Court, has been reached and a final decision is made at the highest possible court. Now, if that is a right, I can go and appeal as many times as I want. How can they discriminate that right based on income? They can't. That's my argument. Tell me what you think. Be sure to like, subscribe if you want. I'm probably going to be posting a lot more videos about this particular situation and my encounters with the police. I did not have my camera with me at the time of my first initial stop, or I would have posted that video. But I'm going to try and record the following encounters with any sort of thing like this. Let me know, follow, give me your opinions. If anybody knows of anyone who's willing to take my case pro bono or under a promissory note that if I win the final decision and they can represent me in a civil suit, I will sign a contract stating that in payment for the original criminal and appellate trials, I will give them, you know, all of the financial judgment in the civil case for unlawful imprisonment and conspiracy to deprive rights under color of law that I file against the court systems that refuse to grant me my my dismissal or not guilty adjudication, if I win. If not, then I will be willing to sign a payment agreement, blah, blah, blah. But I'm not expecting this, but if somebody knows of anyone, please let me know. I'd be very grateful. Alright guys, thank you so much for watching. Like, subscribe, etc., blah, blah, blah.